All right, welcome everyone to our April meeting of our local Inns of Court. I want to thank all of you for taking time out of your day once again to meet in this format through Zoom. Again, we know it's not the most ideal, but it's one that's been very practical for us during this past year. And so I don't have a lot of introductory comments. I do want to welcome any of our guests that might have joined us today. There's not a way in this current format for us to actually get you to interact with us in a direct way, but our hope is that you'll find some benefit from this program and decide that for yourself this is something that you might be interested in the future, and you'll decide to join us as a member of our inn as we go forward into the fall, and what we expect will be a return to in-person meetings. And so some of my executive committee members that I typically have present aren't on our call today. So I'm going to turn it over to Bill, Kim, and Jaron from Team 5. I know he's going to make some comments on behalf of our membership chair, and I think he's also got some comments of his own. And then I'll go to fellow executive committee member Randy Ortley for his treasurer's report. So Bill, if you want to go first.
Yes, thank you. I'm appearing instead of our membership chair, Eric Norvell, who had to take an expert deposition tonight. A couple things he wanted to remind each of you of is that if you have guests that are opposing counsel or co-counsel that you would like to have attend our meetings, please have them do so. We're always welcome new members and new guests. Second, we need to start thinking now about programs for the next term. Our program committee has already met 3 times. We're planning to meet again this month. We've sent out a couple notices for requests for ideas. If any of you have any further ones or haven't yet sent anything, please send them to me this week. You can send them to me at my email, wck@wcklegal.com. Also, in terms of planning for the future, you need to start thinking now about retention and your return for next fall. Our programs hopefully will be in person by September. So if you're interested in returning, whether or not you want to be on a team, please send something to me. Again, wck@wcklegal.com. And finally, the city of Carlsbad has started to open up some of its facilities as of April 1 on a limited capacity basis. Assuming that Governor Newsom's orders go into effect, I would hope that we would be able to meet in person in September. So until then, stay safe and healthy. And as I said, if you have any program ideas or guests, don't hesitate to invite them and start thinking about your return next fall, whether you want to be on a team or as an attendee, but not necessarily signed to a pupillage team. Thank you all.
Thank you, Bill. And with that, let me turn it back over to our treasurer, Randy Ortley. Randy, for treasurer's report.
Thank you, President Washington. I want to announce that we have now crossed over into solvency. We have now collected enough money over the last month that we have a surplus of about $2,800 and change this year, which is very good. Makes the treasurer very happy when we have a surplus. We still have 12 members with unpaid dues, but some of those members I think are inactive. So I'm going to work with members of the executive committee to contact some of these members and ascertain whether or not they are active or not. I know some of them are retired attorneys, and they were billed this year, assuming they would be part of our group, but they may or may not be. So I'm going to try to whittle that down. And I would echo what Bill just said. Please let us know if you're going to renew your membership next year, and please invite colleagues that you know in the bar to join up for the Inns of Court. It's the best way to get CLE that I know of. And once we get back together, it's a great way to not only learn more about the law, but also to have fellowship with judges and colleagues, which is invaluable. So thank you, Bill, for for that. That's all I have tonight.
All right. Thank you, Randy. And I realized I did have one announcement. Steve Burke, who's the president of the North County Bar Association, and I have been discussing for the last couple of months, trying to do something where we would try to use the cross promotion of our two organizations to try to see if we could recruit someone of legal significance that could appear remotely for one of our meetings. And so he was successful working with members of our Inn, including Leslie Adams, to be able to recruit Dean Erwin Chemerinsky, who's the current dean of UC Berkeley School of Law. For those of you that are old enough, you might have known as Bolt Hall. It's the same place. He was the founding dean of UC Irvine's Law School, which is still in the top tier of law schools in the United States. And so he's agreed to be the speaker in June. So you should be getting some information in the next couple of weeks to confirm that information on the date and time that he'll be speaking. For those of you that have not heard him speak, it is a treat. I had a chance to hear him speak in person and to meet him at one of the California judges joint meetings a few years ago in San Diego. He has an encyclopedic memory. He can talk about Supreme Court cases off the top of his head, including who all the attorneys were, who the parties were, who the justices were that made their individual rulings and concurring and opposing opinions and how that related to other opinions that they had. So I imagine, based on what the Supreme Court has done in the last couple of years and how it's been transformed, that he will have a lot to share with us when he meets with us in June. So again, I want to give thanks to Leslie Adams for the work that she did with that. I want to congratulate all those of you that are already members of the North County Bar for being a part of this. And if you're not a member of the North County Bar, you should really consider being one. I think actually our bylaws say that you're supposed to be a member of the North County Bar if you're a member of our Inn. I don't think we've been really forceful of trying to enforce that, but it's certainly something that I would encourage everybody to be a part of because of the great educational and networking opportunities that that organization provides as well. And so with that, and I see my colleagues are posting information in the chat about that information. There's also going to be, and I thank you, Howard Franco, for posting in there. The North County Bar is going to have their virtual dinner tomorrow with Elizabeth Van Cleef, who's a certified tax law specialist. And so you can register for that event by calling their phone number or emailing them. Their presentations are amazing as well. And I encourage those of you that can attend, especially in this virtual world when we don't have to get in cars and drive places, to at least register and log on from your computer and listen in from home or your office or wherever you are to the presentations they have in store. And with that, I'm going to turn over to Team 5 with Judge Parker and her team as they talk about the issues that we're going to have in our cases. And Judge Parker or Mr. Muir, whoever's going to take it for your team, I turn the panel over to you.
Yeah, I think I'm up, Judge. Thank you.
Thank you, Rich Muir. You take it.
Okay, good evening, everyone. The topic of our presentation this evening is the art of active listening, practical tools for lawyers. Now, as lawyers, we are constantly working on improving the skills common to our practice. Cross-examination, oral arguments, voir dire, writing persuasive motions. Yet the one skill that we tend to neglect is the ability to be good listeners. It is often neglected, but in truth, it is one of the most difficult and challenging aspects of our practice. This is my 51st year of practicing law, and I must admit, this is the one skill that I have to constantly work at. As they say, it's a work in progress. This is developing good listening skills is something never taught in law school. It's never going to be the subject of any educational seminars. yet it encompasses, when you think about it, everything that we do in our practice. And it also encompasses everything that we do in our lives. Developing good listening skills is something that helps us in our relationships with our spouses, our children, our friends, and even, yes, our adversaries. So the focus of tonight's presentation will, how do we become better listeners? Now, before we begin our program, to get you into the spirit of things, we're going to play a clip from Irving Younger's acclaimed video on the 10 commandments of cross-examination. When you watch this video, we're going to be focusing on commandment number 5, which Younger says is listening to the witness's answer. Now, some of you may not be familiar with Irving Younger. He was an acclaimed trial attorney for many years in the state of New York. He became a judge in New York and later taught law at the New York University Law School. He has given popular seminars on trial practice all throughout the country. Ray Gomez and I, in the early 80s, attended a seminar, live seminar that he gave at the University of San Diego in California, in San Diego. That was terrific. He was absolutely terrific. And I still have all his notes that I took from that seminar. So without further explanation, I'd like you to watch this clip. I think you will enjoy it.
Fifth commandment. The fifth commandment is is the most recent addition to this list. It refers to a phenomenon that I had been aware of for a long, long time, but just hadn't been able to figure out. But I think I figured it out now. And this was the phenomenon. Let me tell you about it before I give you the commandment. You're sitting in court. A lawyer is cross-examining. He asks a question, and he gets an unexpectedly favorable answer. You know, just an answer that's inconsistent with all the rest of the evidence. An answer that's contrary to the laws of the universe. It just can't be. The answer makes his case for him. At a minimum, it blows this witness right out of the water. And almost every time, when the lawyer gets that kind of marvelously favorable answer, guess what? He does nothing with it. He just sails on, as if the answer had never been given. And I finally figured it out. Do you know why the lawyer does that? You know why he sails on as if the answer never had been given? Because to him, the answer never was given. He hadn't heard it. He hadn't heard it. And you know why he hadn't heard it? Well, 2 reasons. Reason number 1, he didn't know about this, what is it, 5th commandment, which is simply listen to the answers. But the reason why he hadn't been able to comply with that 5th commandment, the reason why he wasn't listening to the answers, is a perfectly natural human reaction to the terror of being the cross-examiner. Let me put into words what's going through your mind when you stand up to cross-examine. And it can be the first time, it can be the last time, but for God, you know, this is the way it is. Oh my God, I got to cross-examine. What am I going to do? Why did I ever go into this work? Well, here I am. What is your name? I got it out. All right, now what should the next one be? Where do you live? Okay, we're still going. And you see, you're so wrapped up in your own psychic processes that you have no energy left over for listening to the answer. But you must listen to the answer against the possibility that you're going to get one of those extraordinary answers. The 5th commandment, ladies and gentlemen, is listen to the witness's answer. And I want to illustrate that commandment with a story. Now you must understand, this story is not literally true, but it is poetically true. And so far as I'm concerned, it is true. All right? Come back with me, what was it, 5 summers? When every one of us was glued to the television set. What was happening? The Urban Committee, the Special Senate Committee, was conducting its investigation of the Watergate affair. And what an extraordinary time that was. As it gets longer ago in time, you realize how wonderful. Here, it was as close as any of us will ever come to being a citizen of 5th century Athens. And we didn't sit on the stone seats of an amphitheater watching a tragedy unfold, but through the technology of it, the 150 million of us were an audience. and we watched something akin to a tragedy unfold, and we experienced feelings of pity and terror and citizenship beyond anything any of us will ever again feel in our lives. Now, I don't want to get into any political arguments, so I just lay my cards on the table. I tell you that I believe that those senators deserve the thanks of the Republic, because I think they probably saved the Republic. But having said that, I also say that none of those senators struck me as an intellectual giant. And of the bunch of them, my favorite was Senator Gurney of Florida. Do you remember Senator Gurney? He's no longer a senator, but he's indicted every month or so down in Florida. You read about it in the papers. I had never heard of Senator Gurney before the hearings went on television. But in the first hour of watching, Senator Gurney became my favorite. Senator Gurney was the handsomest man I have ever seen. He was Central Casting's idea of the senator. Do you remember? The gorgeous white hair and the finely chiseled features and the Roman senator's profile. And to go with that wonderful appearance, no measurable IQ. None at all. Right. And do you recall the ground rules? Each senator had, whatever it was, 10 minutes to ask questions of the witness, and then it went to the next senator. Well, I realized very early in the game that the thing to do was always watch Senator Gurney, because here was the camera on the fellow sitting to his right. The rest of the nation was watching that fellow, but I was watching Gurney, because he spent the whole 10 minutes getting ready. He gave himself a facial, and he got the skin muscles nice and tight, and he combed his hair a little bit, and he made gestures at the television director to be sure that the profile was just right, and finally the little red light went on, and Senator Gurney was on camera in front of the nation. Now, the questions were unimportant. The staff had written out the questions. I'm not concerned with that. But this is what it was like when Senator Gurney asked the questions. There he was, you know, the profile, just thrilling. He said, "Mr. Witness, when you entered the Oval Office, what did you see?" And the answer would come something like this. "Well, Mr. Senator, I walked into the Oval Office, and there was the president, naked as a baboon, prancing around on all fours with the gemstone file in his mouth." Senator Gurney: "Ah, and when did you next see the president?" Well, that's not listening to the answer.
I hope you enjoyed that. What we're going to do is we're going to divide our program into 3 segments. And in our first segment, Judge Parker will talk about bad listening she has experienced as a longtime sitting judge, hearing lawyers appear before her. And then she's also going to talk about some things she's learned as her own listening skills. After she finishes, she'll be followed by Dale Ornish, who will speak about developing what is good listening. What does it mean to be a good listener, and what cues do you look for in helping you do that? And then Doug Harvey is going to talk about the components of active listening and why they are important. And finally, Tom Fisher is going to talk about resolving disagreements in dialogue and conversation using good listening skills. Okay, it's all yours, Judge Parker. Thank you.
Thank you, Richard. I'm dating myself when I say this, but for those of you who saw Irving Younger in action back in the day, you know that attempting to follow one of his performances can be a daunting prospect, but I shall do my best. We're talking tonight about active, effective listening. The snippet of Judge Younger's presentation that you just saw provided a teachable moment on what it can cost an attorney if he or she is too focused on the next questions to be listening to the answers. But what might be humorous for us to hear now can be devastating to an attorney who loses focus in the moment. I was asked to give you a couple of examples tonight of both good and bad listening from the bench perspective, and I'll start with the bad listening. I'm sorry to say that pickings are hardly slim when it comes to providing examples of bad listening, as witnessed by me as a bench officer. We are, after all, human beings, and our busy lives often pull us in many different directions at once. One example I can give you is a criminal bench trial I presided over back in the pre-COVID days. Because it was a bench trial, I was to be the trier of fact, and I was particularly focused on the main prosecution witness who testified. The prosecutor meticulously walked the witness through all the exhibits presented, being careful to ask all the usual foundational questions that would help get those exhibits into evidence later on. From time to time, I would glance over at the defense table, and I saw defense counsel looking down, engrossed in his iPhone, sometimes scrolling or even texting. Now, I don't like to jump to conclusions about people. I'd like to start with the assumption that attorneys know what they're doing, that they know the rules about phones in courtrooms. Some actually do use phones to take notes, but since this particular attorney also had a laptop with him that day, that seemed like an unlikely explanation. In hindsight, I perhaps should have said something earlier, because what happened was this. At the conclusion of her examination of the witness, the prosecutor asked me to receive into evidence several exhibits she had asked about. I then turned to defense counsel and asked if he had any objections to the exhibits. And his response was, "Well, I most certainly do, Your Honor. I object to each of them on grounds of lack of foundation." Pause. "Counsel," I said, "could you please be more specific as to what foundation you thought was lacking for each of the documents, because I believe I heard the prosecutor ask all the usual questions." "Well, I didn't hear any such questions or answers, Your Honor." Pause again. "Counsel, I can assure you the questions were asked and the necessary testimony elicited. Perhaps you missed it because I observed you looking down at your cell phone several times during the testimony." Defense counsel then responded to me with his client sitting right next to him. "You know, Your Honor, I just don't have this one case. I have a lot of cases. I have to keep up to speed on everything. I don't have the luxury of ignoring these cases for days at a time. I have to check in regularly." Well, let's just say that things degenerated after that. Defense counsel became very defensive, no pun intended, as I overruled his objections to the exhibits. What I'd like you to take away from that example is the following. We all have very busy lives. I assure you, lawyers are not the only ones who lose their focus. Judges do too. I and all of you have to constantly prod ourselves to stay focused and tuned in. At any given moment, when you sit there at trial or at a deposition or even at a meeting, you find that your mind can wander, sometimes to your next case, to your child's music recital in a couple of days, or even to how the Padres finally got a no-hitter on the record books. The point is, don't think for a moment it can't happen to you. It will happen to you. And that's okay, because as I said, we're all human. What you just need to do is find a way to get yourself back on track quickly. What worked for me when I was an attorney and found my mind starting to wander is to look to my left or to my right to the person sitting next to me. That person, my client, was depending on me to keep my focus, to listen for opportunities, to help his or her cause and not mess up. If you remember that, then your ears will perk up, you'll get back to the matter at hand, listening closely to what is happening around you. The attorney in my example lost sight of that truth. That defendant, by the way, was facing a possible max sentence of life in prison. And the end of the story is that the counsel was ultimately removed from the case. So that's an example of what can happen if you're not listening. But active listening is not just hearing what is going on around you. As our group will demonstrate throughout this evening, good active listening also means taking stock of what isn't being said. It also means matching what is being said with the behavior or demeanor of the person speaking, and noticing, for example, if there's a disconnect between the two. It means listening to how things are being said, the tone of voice. Therapists, if they are good therapists, are skilled at this kind of active listening, but attorneys, judges, and mediators all need this skill as well. I have just a few more moments to give you an example of what I mean by this. My first assignment as a judge was in a family law assignment. And now if there's any judge who needs a therapist's active listening skills, I can tell you it is a family law judge. I did that assignment for 5.5 years. I'm still doing it on occasion, and I doubt I could have survived it unless I had improved my listening skills. One day, I had a domestic violence restraining order hearing. The complaining parties were two young brothers, aged about 16 and 13, I think. In family court, you can bring your own DV request if you are 12 years old or older. Sadly, the complaints were brought by the boys against the couple who had just recently adopted them from a Mexican orphanage. And the charge was that the adoptive mother had tried to seduce and sexually abuse the boys, and her husband had done nothing to stop it. So I started with the older boy, and after all the necessary introductory preliminaries about what it means to testify in court and tell the truth, and whether or not the boys wanted to proceed with their hearing, I started to inquire about their allegations. So here's just some of the things I noticed. The older boy's tone was flat and emotionless. He sometimes smirked when he wasn't speaking. He gave general answers with few specifics, but it was horrible testimony. Here's also what I noticed. His brother sitting next to him, younger brother, was terrified. He looked terrified the whole time. He kept looking down, and when I asked him questions, he would constantly look to his older brother before answering them. Well, after I'd heard what the boys had to say, I leaned back in my chair and thought a bit, and then leaned forward and said to the assembled group something along the lines of, I don't know exactly what happened between these parties, but I don't think it was sexual abuse or violence. I turned to the boys and said, I'm having a hard time believing your testimony, and I told them exactly why. I told them there could be a whole host of reasons why they were acting the way they were, why their demeanor was what it was in court. But I, as the trier of fact, had to put together everything that was being told to me by both parties in the case. And under the circumstances, I couldn't find them credible. But I explained, it was clear to me that something had gone terribly wrong in this family. I just didn't think domestic violence restraining orders were the way to go to fix things. Importantly, even though I had denied the relief they had requested, I wanted these young men to feel that someone had heard them. I wanted the parents as well to get the help needed to put this family back on a healthier course. I felt that the case belonged back in juvenile court where the adoption had occurred, because there the boys could have their own counsel, there'd be a social worker involved, and the time could be taken to really dig into what was happening with this family. So at that moment, when I mentioned sending the case back to juvenile court, I was advised for the first time that in fact there already was a new proceeding in juvenile court, which is something it would have been helpful to know earlier. But what I decided to do was stay, not issue an order. I stayed the restraining order proceeding and allowed the proceeding in juvenile court to go forward. And I also placed the boys in the interim with a family friend who happened to be in the audience that day. Now, I don't know what ultimately happened in that case, whether the adoption was dissolved or whether the family got counseling and everyone reconciled. I don't know. I do know that I never saw them again, and the continued hearing was vacated in my court. The important takeaway from that experience is that there's just no substitute for bringing all of our human and professional experience and insights to bear when you're listening to the story of a client or a witness or a party. Listen to what is being said and what is not being said. Listen and be attentive to how it is being said. Don't let your mind just default to the easiest explanation or solution for what you are hearing. I could have just dismissed the case because I didn't find the boy believable, but that would have done no good for this family. Domestic violence may not have occurred, but something had gone wrong after the boys were adopted. By actively listening to the boys, I could hear they were in pain of some kind, even if I could not find that they had been abused in the way they had alleged. I wanted the boys to know that I had heard them, that I recognized there was a deeper problem there, and it needed to be addressed by someone, but clearly DV court was not the place for them. It was a bit out of my wheelhouse at that point in my family law judicial career, coming up with that temporary fix. But I soon learned that being a judge required being fully present for those hearings and to expect the unexpected, because that would prove to be over the course of the next several years what I really needed to do in order to do justice. Good listening is often the key to accomplishing justice. Well, that's it for me. I thank you for your active listening. And now I'd like to turn this over to Doug Barker, Dale Ondas, and Thomas Fisher, who are going to share with us some important elements of active listening.
Thank you, Your Honor. What Dale, Thomas, and I are going to do is to break down active listening into components. Dale is going to lead off and talk about the definition. What is active listening? And to talk about some of the cues that you as an active listener are liable to demonstrate to show the speaker that you are active listening. I am going to talk about some of the important components of active listening, and then Thomas will finish up by talking about how to set up and manage a conversation that you expect has the potential for being contentious, that you know that you're going to disagree with the other person in the conversation, and how to diffuse those problems before they start. Let's begin with Dale.
Active listening involves listening with all your senses and giving full attention to the speaker. There are varying definitions, all similar, but with different emphases. Active listening is a technique of careful listening and observation with nonverbal cues and feedback in the form of paraphrasing. It is used by judges, as you've heard from Judge Parker, and counselors and mediators in resolving conflicts and disputes. LA Superior Court judges in their training of temporary judges succinctly describe it as listen, clarify, interact, and repeat. Another variant is it is a way of listening and responding to another person that achieves mutual understanding in order to resolve or diffuse a situation and seek solutions to problems. This would be applicable to a traffic stop or a neighbor dispute or a domestic dispute. And another variant is one which emphasizes the listeners showing full concentration and understanding by responding and remembering what is being said rather than passively listening. So what are the tools of the active listener? Eye contact, a nod of the head, a smile, or where appropriate, a grimace. Certain hand gestures that signal you understand or you concur in what's being said, demonstrating interest or empathy by leaning toward the speaker as the story is being related. An occasional, I see, or I understand, are just short statements that indicate you're engaged in active listening. Repeating or paraphrasing accurately what is being said by the speaker. And as the judge pointed out in her remarks, reading the body language of the speaker. Is it consistent with what is being said? And finally, where appropriate, taking a note or two about what's being said to indicate you're paying attention. And finally, it's not looking at your phone. Doug?
Yes, thanks. So a little test for all of you. If you have been an active listener this evening, then you know that at this point, Doug Harvey is supposed to be speaking to you, but he got called into a deposition at the last moment, and so I will fill in. Some of the most important elements of active listening is, well, first of all, I suppose I should say that the fact that we're talking about active listening is a bit embarrassing to us all. And that is because in generations gone by, active listening was just the way that people communicated with one another. Interrupting another was at the height of rudeness in terms of social folkways. It ranked right there with spitting on the sidewalk. But as society and media has sped up and we've become a world of 20-second sound bites, it's routine for people to interrupt one another, even in friendly conversations. And when you see where the speaker is going, you interrupt to save time. We've got to move on. I understand what you're saying, so I'm going to interrupt you, and we'll continue the conversation. In discussions where people have disagreements as to their points of view, it can cause the entire dialogue to break down if it becomes a contest in who it is that can interrupt one another. One of the things I reflect on is that as young lawyers, we're taught that when we prepare our clients for depositions, we tell them that they are to listen to the entire question before they begin their answer. Now, part of the reason for that is to not burden the court reporter, but part of it is to make sure that you've heard the entire question, there's not any twist at the end, and that you're responding to the appropriate question. That kind of admonition that we give to our clients routinely is one that we should address to ourselves as well. Another thing about active listening in terms of its demise is that we're, again, too busy to really focus and lock in on what it is that the speaker is saying without doing something else at the same time. As Dale mentioned a moment ago, how many of you right now are checking your phone, see if the email or a text is there? And so when we're multitasking, when we have electronic communications, phone calls or whatever, that kind of tends to carry forward into face-to-face conversations. And so instead of demonstrating to the speaker that you're all about what that person is saying, you're sending a different message, and that message is that I keep talking, but I'm going to continue to do what it is that I'm doing at the same time. I assure you, I'm listening, but I'm going to also look at my phone, and that's not appropriate for a whole host of reasons. Another thing that is important and has already been mentioned by both Dale and Judge Parker is this business of not only being focused on the cues that you are giving to show I am an active listener, I do care about what you're saying, is also the listener reading what it is that the speaker is saying. And I don't need to belabor this because Judge Parker and Dale both spoke to it, but the studies show that 85% of human communication of feelings is done non-verbally. So if you really want to understand how it is that a person is feeling, you need to be considering, while that person is speaking, their tone, their tempo, their volume, their word emphasis, facial expressions, head movements, hand movements, and body language. That said, Thomas, let's talk about a discussion you're about to enter that may go wrong if ground rules aren't set.
So perhaps epitomized in social media more than anywhere else today, many people are content to mock opposing viewpoints, often in 280 characters or less, depending on what platform you use. And the sarcasm and the condescension are used with little regard for reasoning. These same inclinations can manifest themselves even in more traditional communication environments, even if not overt, as has been discussed. It can be through less subtle facial expressions or body language. And even sometimes, as we've heard in court, who of us hasn't at one time or another helped ourselves to some of these bad habits regarding communication. Given that we have the ability to speak and listen more effectively in amounts far greater than 280 characters, we can commit to understanding and communicating in a more meaningful way through active listening. Part of that commitment is to set up a conversation properly such that the meaningful conversation by both parties can occur. If you have a true interest in finding out why someone has a particular point of view, different or sometimes even aligned with your own point of view, consider the alternative approach. If the speaker is making an argument or trying to be persuasive, seek to understand the why of what they're saying. To the extent possible, try not to judge while you're listening. Start with a personal commitment to, as Walt Whitman would say, be curious, not judgmental. Judging the speaker or the content while the speaker is making his points invokes a competing thought process in which you're likely to get in the way of active listening and more fully understanding what's being said. Understand fully the other person's point of view before judging or, reacting to them. And if you're going to interrupt periodically at an appropriate point, start your response with why, or can you explain more fully, or I don't quite understand. Distinguish in advance between your promise to listen on the one hand and whether you'll agree with the speaker on the other, and communicate to the speaker, I may not agree with what you're saying, but I promise that I'll understand everything you say and I'll wait before responding. So in setting the tone for the conversation, there's several openers you can use or several introductions to the conversation. And a few examples. It is to tell the other speaker that it's pretty clear you and I have very different views on this issue, and I'm interested in learning some of your reasons why you believe what you do. A little more, another example I should say is to tell the other speaker that it bothers me that so few people are genuinely interested in finding out about the reasons for another person's perspective. Well, I am truly interested, so please tell me why you feel the way that you do. Again, a good opening is to promise to simply listen and let them know that you're not going to judge them, that you're simply going to learn about their point of view. Promising that you won't interrupt them unless you genuinely misheard them or don't understand a point and you need some clarification. And finally, when you've let the person know that when they have finished sharing the reasons for their views, perhaps they would like to hear your own reasons and what your own views are, and that they'll extend you the same courtesy that you are offering to extend to them. But that obviously will be up to them. Rich?
Okay. Thank you. Thank you, gentlemen. Our next segment will feature a virtual Zoom mediation involving two sisters fighting over jewelry left to them by their deceased mother. In this mediation, the mediation judge will be played by Joe Stein, and the two sisters will be played by Sylvia Keating and Morgan Small. Now, Joe will intentionally demonstrate bad listening skills in mediating this dispute. And when he's finished, he then will go over it again as to how the mediator could have done a better job in listening to the two sisters. Okay, Joe.
Thank you. Hello, ladies. Thanks for coming in for the Zoom mediation today. As I understand, let's get down to business. As I understand, what happened is your mother died and you have a dispute regarding divvying up some jewelry. I think it's a little silly that we have to go to mediation for that, but it's a little troubling you couldn't work it out on your own. But I'm here. Let's see what we can do. The meter's running. And by the way, I've got a 2:00 tea time, so let's make this quick. Okay, ladies, let's get this done. All right? Okay, Bertha, what's all this fuss about?
Oh, where do I start? Basically, the thing is, Judge, my sister doesn't understand what the word compromise means. You see, this is the thing. Our mother and grandmother left jewelry that she owned and our grandmother owned to the estate. Now, our grandmother was a world traveler. She was married to a rich guy, I think a tax lawyer, and he let her buy anything she wanted. And she did buy anything she wanted. She got some really good, she bought some really beautiful jewelry, some really unique pieces that are worth a pretty penny today. But that's not the issue. It's not the money. It's the sentiment. See, my grandmother, she would encourage me to have tea parties in the garden with her. And she let me play dress up with her jewelry. And my favorite piece of jewelry to play dress up was this pink carat diamond ring. Oh, I can remember it like it was yesterday. You see, that pink diamond ring meant something to me. It had a lot of sentiment, and I think I deserve that ring. And I don't understand why that pink ring, diamond ring, why it would not go to me right off the bat.
Okay, all right, hold on. I'm going to interrupt you, big sis. Judge, what my sister's failing to mention here is that the ring is worth more than the rest of the other jewelry combined. It's a 5-carat pink diamond ring, for crying out loud. No, I'm not just going to hand it over to her without a fight based on some sentimental attachment to it. It's worth a lot of money. If she wants that ring, then she doesn't deserve any of the other jewelry. That way we're both getting the same amount money-wise, be even Steven here. Judge, I'm sure you can understand. Can you set my big sis straight, please?
Now, ladies, come on. Let's use a little common sense and be reasonable here. You know, do you really want to spend 3 hours at my rate of $500 an hour on this nonsense? Come on now. Perhaps I just should tell you what to do. You know, I've got that tea time, and I'm gonna make it. I'm not gonna let my partner down.
Hey, wait a minute. Judge and Gretchen, would you just listen to me for a minute? This isn't about the money. This is about the sentiment. I mean, really, do you honestly think that I don't deserve some of those things that Mom had based on sentiment? Come on, Gretchen. Really, you must understand that Mom and our grandmother had real sentimental attachment to some of this stuff. I mean, why should you get all the jewelry and I get nothing? I mean, Mom's wedding ring, her anniversary ring, her pearls. I mean, come on, Gretchen. You're just being unreasonable and you're not being fair. I mean, really.
You're actually so hypocritical. It's hilarious. Where was this sentimental person the other day when we were dividing all of the fine china? Mom loved and cherished her tea sets, and all you cared about at that time was Googling how much each was worth so we could divide evenly. I told you the blue Hungarian set was one of my favorites. And you told me, well, too bad, because if I wanted more than one, then I would have to pay for it.
Listen here, Gretchen. That has absolutely nothing to do with it. Nothing. We barely even had that stuff out of the closet. We didn't even look at it. That has no sentiment value to it.
Okay. I need to prevent a cat fight here. We're not talking about the Hope Diamond, are we, ladies? We're talking about some jewelry, maybe some costume jewelry. Come on now, let's be real. You know, let me get the big picture. We're talking about jewelry and spending the type of money that you're spending to have me referee this dispute. Come on, let's look at the big picture. I'm going to tell you what to do here. It's really quite simple. I've heard a lot of this stuff. Let's just cut to the chase here. Big picture is, number one, get the jewelry appraised, all of it. Number two, spread the jewelry, all the items out on a great big table. Number three, each of you, one at a time, going back and forth, pick an item of jewelry. At the end, one person's probably going to have more value than the other. And then you do an offset. You pay a little money so it's even Steven. Simple, easy, reasonable, don't you think?
See, exactly. He gets me. This is about being fair.
Hey, look, being fair doesn't have to do with just monetary stuff. Come on, Gretchen, you're so cruel and you're so cold. Mom's stuff actually meant something to me. I wasn't just shopping around and waiting for her to croak so that you could go and pawn her things. No. You really don't deserve anything. You wouldn't appreciate it.
How dare you?
All right. Time out. Enough of this blah, blah, blah. I don't want to be impolite, but I got to keep my golf partner satisfied, and I got to be on that first tee. I got the clubs in the car. I need to go to the driving range, take a few practice shots before we start our game. I got to get my golf shoes shined, and then I got to meet the partner. One of you ladies doesn't get it. You don't get why we were here. It's simple. You've heard my solution. I suggest you take it.
All right. Well, hopefully you guys enjoyed our vignette. We're now going to step out of character and explain and analyze how the mediator in this case did not show active listening. There are 5 major points of active listening, which are to pay attention, show the speaker you are listening, provide reflective feedback, defer judgment, and respond appropriately. So the first is to pay attention. In our case, the mediator, Judge Rutherford, did not pay attention. He failed to observe the 2 sisters really objectively. As a mediator, he should have looked for the emotional content as well as the verbal cues to recognize how the sisters were speaking and what they were actually saying. For example, the mediator should have paid attention to the substantial difference in the ages of the sisters. Paying attention should have yielded the backstory about what the sisters were fighting about and why. If the mediator had inquired into their age gap, he would have learned that the mother was desperate for another child after raising the demanding, spoiled Bertha. And Bertha, who was the spoiled brat, was constantly draining her mother for funds, always demanding her mother fund a wealthy lifestyle, no matter the cost. The mother, fed up with Bertha, took lots of very expensive experimental fertility drugs to have another child. The result was Gretchen, her much less demanding and loving daughter. Neither ladies were forthcoming about this history. Gretchen was visibly angry and resentful with her older sister and her selfish lifestyle, just trying to collect any funds she could gather. In this case, the pink diamond ring was the surefire asset that could be turned into dollars for Gretchen, who felt she had a fraction of her mother's attention and money and assets that were wasted on Bertha. The second point is to show the speaker that you're listening. Throughout the scenario, if you watch the mediator, failed to give really the verbal or physical indications that he was listening to either of the sisters. The mediator could have showed physical indications by nodding his head and understanding when either ladies were speaking. Instead, he was constantly looking off screen and he seemed to be uninterested in what was transpiring at all. He failed to give verbal indications as well that he was listening by simply saying, or yes, I understand, or okay. He would have showed the ladies he was actively listening to their explanations and concerns.
Thank you, Morgan. I apologize. I had technical difficulties and disappeared for a while. My apologies. I will discuss the third element of active listening. And as Morgan mentioned, there are 5 elements, as Joe will reiterate and finish up the program. What I'm going to talk about is the third element, which is providing reflective feedback. In other words, mirroring back what areas they are talking about, the parties, by asking how and when questions as we listen for these 4 areas. 1, how the parties feel, legitimately or not, whether we agree or not, their feelings are real to them. Secondly, what they think about each other. That's important because you kind of gauge, are these people really capable of entering into a resolution and an enforceable settlement, or will it just blow up in everyone's face? Third, what are the facts as the parties allege them? And objectively, what are the facts here? And finally, what do each of the parties want? I'll go back to the facts in a moment because I discovered something really, really interesting, which I'll share with you very briefly. Basically, if you remember, Bertha just kept saying, I'm not interested in the money. It's just sentiment. Gretchen's a witch. She doesn't deserve anything. And Gretchen is the one who comes back and says, hey, wait a minute. Number one, she's not telling the truth. She is interested in money because why else would she be Googling the price of the china as we're taking it out of the cabinet? You notice Bertha didn't mention that. She denied it. It wasn't worth anything. She described it as crockery. And also, too, you'll notice that the 5-carat pink diamond certainly was a lot was worth a lot more than just sentimental value. Now, the mediator failed to ask follow-up questions, how, why, and when, to what Bertha and Gretchen said. If he had, and I apologize for referring to my notes at times, he would have learned what they each wanted. They each wanted the ring. But why did they want the ring? Secondly, he failed to even ask questions about the auction or suggested appraised value of the 5-carat diamond ring. And as we said before, the elephant in the room is that the estate had no money, basically. The only thing that was left in the estate for these two women, these two girls, were the jewelry and the china. And he also did not ask questions and analyze, pay attention to their anger and resentment toward each other and what they considered a fair division. Now, I'm going to go back to the facts. What the mediator could have done, just as I did very briefly, by just looking up the internet, you know how they're saying, oh, the china isn't worth anything? Well, guess what? I found out possibly differently. The pink carat diamond ring, I just Googled it, and guess what I found out? In the auction, May 2016, there was a 5.03 carat diamond ring, pink, sold at auction for $2.9 million. Now, this sounds like a lot of money, but wait a minute. You know that china? She mentioned that she liked the Hungarian china. Joe didn't ask a thing about these things about the china. One, was it bone china? Was it old china? Was it new china? Where was the china from? Was it Chinese? Was it American? Was it old? Was it new? Because guess what? This is a what if. I found this out. There is a very rare Chinese porcelain that could have been in that collection that he could have found out about. It's called roux ware. And what it is a small bowl that fits into your hand. It's sold at auction. There are like 100 items in the world. It dates to the Song dynasty around 1100, and it sold at auction, I swear to you, for $37 million in 2017. Compare that amount to 2.5 million. None of these things came out. None of them. Heaven knows what was in this stuff. So, with that, I finish, Joe, and I turn over to you.
Thank you, Sylvia, very much. An effective mediator, just like an effective attorney, is a good listener. And in either case, whether the attorney or mediator, you do three essential things. Number one, you establish trust and respect with the people before you. Number two, you respond appropriately, not just to facts, but feelings. We're not robots, okay? We're human beings with feelings. And then four, you defer announcing any judgment until an appropriate time. You don't do it prematurely. Judge Rutherford did everything wrong. He failed in each of these three critical components of active listening. Let's go down real quickly, examine those. Trust and respect. He didn't show any respect for them. He called them guys. He demeaned the fact that this dispute was, they couldn't work it out themselves. He belittled them. He said it was silly. He did not effectively bring himself into the conversation, the dialogue between the two ladies. He stayed aloof. He was focused on what? His tea time. So he wasn't engaged. So he was impatient. Okay, he was thinking about his own interest, although he should have been thinking about them and paying attention not only to what they said, but any cues that he could get from their body language. He was completely oblivious to that. In short, he didn't pay attention. Second thing, feelings. He could care less about them. He was caught up in the fact that he's so smart as a retired judge. He knew what's best for them, and he was going to tell them. You recall very early in the vignette, he showed his impatience. He says, well, maybe I should just tell you what to do. And finally, he did that. Okay, so he wasn't in tune to their feelings at all. He was looking at his watch. He was practicing his golf swings. He was looking, he was texting on his iPhone. He was doing everything to not engage. In other words, there were many keys if he had asked the right question and been paying attention, or he could get a lot of this information that Sylvia was talking about. He was oblivious to it. He wasn't curious. He wasn't concerned. Those are fundamentals that any good mediator should display. He did the absolute wrong thing. Okay, so he failed in terms of being part of the conversation, understanding their feelings, picking up on their cues, not just verbal, but nonverbal cues. And the final thing that he did wrong was he didn't defer announcing his assessment or his judgment till an appropriate time. In short, he rushed the gun. He was too impatient. Why was he impatient? He was concerned about a tea time, not with this dispute. He thought that they hired him, that he was hired because he's so smart and he was a former judge, that's just to tell him what to do. That's not right. That's not the reason. So he jumped the gun, and in a good mediation, there may be a time, there often is, for a mediator to express an opinion or to make a recommendation. But that has to be at the right time. You do not start the mediation with that. You don't rush that. You actually invite parties. Would you like my thoughts on this after you've reached an impasse or there's some difficulties at an appropriate time? This was not an appropriate time. His concern was making his golf date and not so much listening and helping to craft a solution that the two ladies can live with. Not that he was necessarily Solomon and knew the right thing, but he should have given them an opportunity through his guidance, through his facilitation, to resolve the matter themselves. He did not. He failed horribly on this. So as an attorney, there's parallels to an attorney. When you have a client in the office, new client in the office, you don't spend 3 minutes with him and then all of a sudden say, that's it, time out, I'm going to tell you what to do. You just lost that client. The client wants to be assured that you understand his situation or her situation before showing your legal training, your expertise, and helping them with their problem. But you can't jump the gun on that. There's a wise adage that says, first you try to understand, then be understood. You don't get the cart before the horse. Understand what people are saying, truly understand facts and feelings, and only then at an appropriate time is it proper to render a legal judgment and assist, if it's in an office consultation, assist the parties with their legal problems. Don't get the cart before the horse. Don't rush it. You know, there's a reason that we have one mouth, but two ears. Be sure that your ears are not just an appendage on the side of your head. Use them to listen, to reflect back, to understand, and to show the parties before you, whether it's in a client consultation or in a mediation, that you truly were listening and you understood their situation. In short, don't be like Judge Rutherford. Rich, back to you.
Okay. Thank you, folks. Our final segment will feature a vignette of an initial attorney interview with a prospective new client who is outraged by the fact that he just got arrested, he believes falsely, at a protest rally at a popular restaurant that was recently closed down because of COVID-19. The client in this vignette will be played by Daniel Watts, and the attorney will be played by Iona Runnery. Okay, Iona, why don't you start the interview?
Hello, Daniel. Pleased to meet you. I understand you've had a rough week. Have a seat and let's see if I can help you.
Oh, dude, I wish it were just a rough week. A rough week sounds awesome compared to what I went through. The cops, they screwed me over, man. I didn't do nothing, but they arrested me, dude. That's not right.
It sounds like you had an awful experience, Daniel. Why don't you tell me what happened?
Okay, so I was getting dinner last night at Amore's. They're my favorite restaurant. So good. Anyway, when I got there, there's this big crowd of people all in front of the restaurant. Like, why? You know? And I asked one of the guys, he said the restaurant just got shut down because there's all this like coronavirus, man. And him and all these people were protesting. Dude, I didn't know the restaurant was shut down or I wouldn't have come. I don't protest, man. I just want to eat at Amore's. They got good spaghetti, man.
Yeah, sounds like you were just there for a nice dinner, not to protest.
Dude, I was not protesting at all.
Uh-huh. Yes, you were there to eat dinner. So what happened next?
So I see my neighbor in the crowd and I go up and say hi. Then all these sirens start going off and these cop cars are coming up. Dude, I was freaked out. This never happens at Amore's, man. And my neighbor and all those guys, they were all peaceful, you know?
Yeah, I'm sure you were surprised. What happened after the police arrived?
Well, this cop gets on his megaphone and he's all, "This is declared to be an unlawful assembly. Everyone is ordered to disperse immediately or be subject to arrest." Using his vocabulary to try to intimidate us, you know? Yeah. So anyway, I try to get to my car, but I can't move, man, on account of all the people in the crowd. The crowd was crowded, right? That's why it's a crowd. Then all of a sudden, there are these two cops, and they're right in front of me, and they're all, "We told you to disperse. You're not moving." I'm like, "I'm just trying to get back to my car, officer, but there's this big crowd here, see?" But they wouldn't listen to me. Then they arrested me and took me to jail. I stayed in there all night, and now I got a court date. Dude, I couldn't believe they actually arrested me. I didn't do nothing wrong. So I want to sue these cops. They violated my rights, man.
Wow, I can understand why you're very upset. That must have been a horrible experience. It must have felt crazy to have been arrested and spent the night in jail. And now you have to go to court for what feels like doing nothing wrong. Do you mind if I ask a few questions about the events that night?
Yeah, okay. But I'm telling you, I didn't do nothing wrong.
Okay, I understand. I just need some more information to get a picture of what was happening. What was the mood of the crowd? Was it peaceful?
Dude, so peaceful. That's what I don't get. Like, why the cops had to show up at all. Some people were carrying signs about the shutdown and stuff, but nobody was like yelling threats at anybody or getting unruly.
So it feels to you like there was no basis for the police to disperse the crowd.
Yeah, no bases at all. Not even a first base.
I see. By the way, did any of the officers ever tell you why they felt it necessary to declare the gathering an unlawful assembly?
This one cop said they were blocking traffic because they were in the street too, but I couldn't see, so I don't know.
So you were not on the road yourself and you couldn't see it clearly?
Yeah, I wasn't in the street, so I don't know if that cop was making stuff up or what.
I am curious about something. Could you clarify this for me? You said you went over to speak to your neighbor in the crowd. How was it that you had no trouble getting to your neighbor, yet moments later were blocked by the crowd from getting to your car?
Yeah, so the crowd wasn't so big when I first got there, but it got so much bigger when I was talking to my neighbor. And then all of a sudden we were surrounded. Man, people everywhere.
Okay, I understand what you're saying, but could you help me understand how it was that the officers were able to move so quickly through the same crowd that had you surrounded, yet you say you couldn't move at all?
Most people had already left by then. By the time the cops saw me, there was already this big fat path to me and my neighbor.
Okay, and I'd like to also ask you, why do you think the police singled you out for arrest?
I guess because I was one of the last guys. I don't know why, man. But I heard I wasn't like the only guy arrested. Oh, FYI, by the time the cops got to me, my neighbor was already gone. Mm-hmm. Maybe the cops thought I was taking too long to go. But dude, I wasn't just waiting there for fun, you know. I was going to go.
Yeah. Daniel, how much time would you say elapsed between the time the police told the crowd to disperse and when they approached you and put you under arrest?
Like just a couple minutes. But like I was saying, when I heard the cop on the megaphone, I tried to get to my car, but I was trapped in the crowd and couldn't move. I tried to explain this to the cops, but they just wouldn't listen. What was I supposed to do?
You feel he did not give you enough time to actually move in a crowded situation. Well, it's possible the officers had a right to declare an unlawful assembly and disperse the crowd, if in fact some of the group were blocking traffic. But they would still have to allow a reasonable time for people to comply with the order. And based on your circumstance, it appears they didn't do that. On that basis alone, I believe you have a valid defense.
What about suing the cops for like false arrest or something? Dude, I'm so mad. Look, I looked at on Google and they got to have probable cause, right?
Yes, it is understandable that you feel very strongly about doing something about the arrest. And yes, you're correct. They needed probable cause for an arrest, but we need to look at the situation from law enforcement's point of view as to what they reasonably believed at the time, not necessarily what they learned later. The courts are generally differential to the officer's judgment if reasonable, even if later determined to be an error.
Dude, that's not fair. They didn't have no probable cause to arrest me. I was just standing there. I was in the wrong place at the wrong time.
Well, you're certainly right about being in the wrong place at the wrong time. But first things first, we need to concentrate on defending you on the criminal charges. And as to that defense, the prosecution must prove their case beyond a reasonable doubt, which is a much higher standard than probable cause to arrest you. One last thing I'm still puzzled about. Could you help me understand why the officers singled you out for arrest? Did you say anything to them when they first approached you?
Yeah, well, okay. So I couldn't believe this was happening, right? I'm like, this is what happened to my grandma and grandpa. They were killed in a war a long time ago by these guys, the Gestapo. Really bad guys. Gave me nightmares as a kid hearing about it, man. And when I see these cops coming toward me, all like, I'm all yelling at them. What is this? The Gestapo?
Yeah, I'm so sorry. It sounds like you were reliving a horrible experience, and I'm so sorry to hear what the Gestapo did to your family members. I'm sure that's something no one can erase from their mind. I can appreciate how it could have affected your feelings towards the officers. Well, what you said wouldn't give them probable cause to arrest you, though, as it's protected speech under the First Amendment, but it does help explain why they may have singled you out for arrest. At the minute, in their minds, you probably flunked the attitude test. Certainly doesn't justify your arrest, but it does shed some light on a few things. We'll have to wait to see the police reports to see how they wrote it up. This could be a factor if we can show that your arrest was improperly motivated.
Okay, thank you, Ione and Daniel. I want to go over some things that you did, Ione, in this interview that to me demonstrated some good listening skills. Why did you begin your interview of Daniel expressing your acknowledgement of his anger and anguish over his arrest before you asked him any questions about what happened to him? Why was this important, and what good listening tools can we actually learn from this?
The active listening tool first used in the interview was paying careful attention to feelings as well as to content. And secondly, showing empathy and acknowledging the client's pain and feelings about what had happened to him. Frequently, clients come into our office as angry and upset about what happened to them, with a strong sense of wanting to right a wrong through the legal system. So before launching into asking lawyerly questions, the attorney paid attention to the client's feelings and acknowledged them. It may seem to go against the grain of what we lawyers are trained to do, but it signals to the client that we both heard and felt their pain, and this establishes a rapport with the client that immediately asking pointed questions off the bat does not accomplish.
Daniel, how did you experience the act of listening as far as your feelings were concerned?
I felt like I was listened to, and she understood what I was saying and what had happened to me and how terrible it was. And she didn't cut me off. She let me talk. And eventually that helped me calm down and feel more comfortable with the attorney. And I felt like we could be on the same team.
Okay, Ione, you picked up on some inconsistencies in Daniel's story that needed to be clarified, which demonstrated that you were listening carefully to the narrative. What good listening tool did you use in picking up those inconsistencies? And I noticed you also were careful in phrasing your follow-up questions in a manner not to suggest that you disbelieved him in his version of the facts. Why was that also important?
The tool of paying careful attention is the hallmark of active listening. You don't get distracted by internal thinking, but also you do not turn off your lawyer brain completely while paying attention. You're trying to get a whole picture of the situation. You are in an information gathering phase. Yes, the inconsistencies needed to be clarified without giving the client the impression that you doubt the accuracy of his story. So you phrase the follow-up questions so they come from a place of curiosity, not casting critical judgment or a cross-examination. We need to ask the follow-up questions in a way that does not give the client the impression that you disbelieve the story or are judgmental. The lawyer kept the focus on understanding the client's whole situation and giving them space to share more information that was ultimately critical to the case.
Daniel, did you feel you were being cross-examined during the interview?
No, not cross-examined. I felt like she was trying to get the whole picture and figure out the details of the situation. I was angry about what happened to me, so I didn't focus on giving her every detail. And I was angry at the police, and so I didn't say everything that was relevant initially.
Ione, you sensed correctly that Daniel may have left something important out of his story, him calling the police the Gestapo, that might have prompted them to arrest him. What good listening tool helped you uncover this omission?
Well, the lawyer was paying careful attention in a way that helped her pick up on the omission as well as the inconsistencies. Whether the client left it out inadvertently or intentionally because they thought it would hurt their case, what is important is the attorney gently persisted in questioning the client without making him defensive. Also, the attorney did not cast critical judgment on the client's use of provocative language to the officers, but rather expressed empathy for why the officer's conduct brought up painful memories for the client.
Daniel, what did you feel about that?
Yeah, I felt comfortable with the way that she was responding to me, and I felt comfortable giving her the whole story because she didn't react negatively to what I was saying, and I felt relief that she understood what I was telling her.
Ione, you also picked up on Daniel's possible misunderstanding of the law on unlawful assembly and also on probable cause, and you tried to educate him on the correct law on those subjects. Why was it important to do that, and in a manner that did not make Daniel feel he was being talked down to? What active listening tool did you utilize in addressing those issues?
The role of the lawyer is, after all, to advise and counsel clients on the law. So active listening helps the lawyer do that more effectively. First, attentive listening informed the lawyer that the client had a misunderstanding about the law. And secondly, instead of jumping right in and lecturing and correcting Daniel, the lawyer used active listening techniques to establish rapport and trust before advising on the law, so the client could listen to and be receptive to the advice. Skilled use of active listening allowed the client to become calm enough to listen to the counseling on finer points of law. And third, the lawyer did not use their expertise against the client's feelings about the wrongness of his arrest. The lawyer did not lecture him from a position of superiority, and she gave the lawyer the opportunity to use their lawyer expertise effectively.
Daniel, what'd you feel about that?
Yeah, I agree. She got technical with the legal terminology, but I didn't feel like I was being lectured to because of the rapport we already had.
Okay. Thank you very much for that vignette. I just want to conclude by highlighting or giving you some takeaways from this interview, what we can learn from it. Tool number one is be responsive to the client's feelings before you ask the why questions about what happened. In other words, doesn't benefit any good to cross-examine the defendant or the client at the initial interview. You can always do that later when preparing for trial. It was important that Iona initially said, I feel your pain, Daniel. That's terrible what happened to you, before she asked him any questions. It signals to the client that she has empathy for what happened to him. And it goes a long way in establishing a better rapport attorney-client relationship. Now, tool number 2, take away from this, is when you listen to a client statement in your office, his narrative, be alert for possible inconsistencies in the story that could be exploited by the prosecution. But this is a tricky issue, because when you ask the client questions about the inconsistency, which you should do, you have to be careful not to do it in a manner that the client feels he's being judged and you feel that he's not telling the truth. You notice how Ione, instead of saying, why did you do this or why did you do that, she said, I'm curious as to why you did this. Could you help me understand why you did this? That's a much better way to approach it. You get the material, the information you need without challenging the client as to the accuracy of his narrative. The third tool we get out of this vignette is be alert to the client's possible misunderstanding of the law. But this is also a tricky issue, because you want to correct the client in a way that does not seem like you're lecturing to him. I think Joe made that point in the vignette with the sisters. You don't want to do that. You want to be able to correct them in a manner that the client does not feel he's being talked down to. And I think Ione did a good job of doing that by explaining about the unlawful assembly, that it was possible they could declare it if the street was blocked, about probable cause, what the officer knew at the time, even if it might be inaccurate. That's the rationale of probable cause. I think she explained it in a way that the client did not feel he was being talked down to. And finally, be alert to possible omissions in the client's story. Iona picked up on the fact that there must have been something the client said or did that caused the officers to single him out for arrest. So she asked him about that, and sure enough, he had a bad experience, or at least his relatives did, with the Gestapo in World War II. He had nightmares about it. The cops are coming on to him, and he reacted by calling them the Gestapo. Now, she didn't cast judgment on him for saying that. She didn't say, why, Daniel, did you just say that? Don't you think it upset the officers? She didn't do that. She showed empathy for the client's memories of his grandparents. And then she said, well, I can understand why the officers, now you've told me that, might have been motivated to arrest him just because they got pissed off by what he said. So I think she handled that in a way that was appropriate. The bottom line of the way that this interview was conducted showed the client that the attorney was on his side and was going to try to help him. Look, when a client comes into your office, he's not concerned with all the plaques on your wall, all your fancy furniture, how well-dressed you are. He's concerned with one thing. Can you help me? And that's the purpose of the initial client interview, to gather information, yes, but to demonstrate to the client that you are listening to what he says, you feel his pain, and you genuinely want to help him. Okay, that concludes our interview, folks. I want to leave you with one final thought. Good listening is not waiting your turn to speak. Thank you.
Thank you, Rich, and thank you for Team 5. I often get a chance to teach, including judges in California, and we talk about the value of listening. And what I know is true in doing these trainings and presentations, often the people that pay attention say to themselves, I don't have a problem listening. And that might be true for everybody that listened to the presentation today. So think about this. Think about the slogan like friends don't let friends drive drunk. Friends don't let friends not listen to people. So if it's not you, but you heard some great pointers from this presentation today, think about a friend that you might have that might have trouble listening, and take an opportunity to say, hey, I've noticed this about you, and this is something that I think might help you in the future. And I know Bill Cameron appreciates that back in the day when we used to open our meetings with the quote. I thought I'd end this meeting with a quote from former President Teddy Roosevelt, who was also a law school grad from Columbia Law. And he said, nobody cares how much you know until they know how much you care. And knowing how much you care starts with that active listening that we've heard about tonight. So think about that as you go into the next month. We'll see everybody back in 1 month on May 12th. For Team 6, my team will be talking about substance abuse and competency. And it's got those great competency CLE credits that we all are yearning for. So thank you, everybody. Have a great evening. Enjoy the rest of the month. Stay safe out there. We look forward to seeing everybody next month. Thank you all.